Hello, everyone. I'm Vanessa Antone from NACDL, as you probably remember from previous episodes of Engage and Exchange. As everyone starts to enter the room and get settled, I'm just going to give you all a few preliminary announcements before we kick off this exciting webinar, which we are very pleased to be doing today. As stated in the in the description, it's engage and exchange. We want you to be very engaged. We want you to ask questions and participate. So throughout this discussion, please submit your questions through the chat. If you have any issue doing that, please shoot me an email directly and we'll make sure the speakers get your question. But go ahead, submit them through the chat, and later on we might ask you to unmute and turn on your camera and follow up on the questions and have a discussion. But until that time, I just want to remind everybody to please make sure that your microphone is turned off, that you're muted, and that your camera is turned off. We are recording this, and we love to see all of your happy, smiling faces, but just make sure you remember that you are on camera, and probably keep the camera off until we have more of a discussion part of this. So I think I got through all of the boring announcements, other than I'm going to highlight our speakers for you in the view, but if you're noticing you're seeing a bunch of little squares of everybody's name, you can go up and toggle the view and click on speaker view, and then you'll have a great view of our speakers. Never hurts to remember all these great Zoom tricks. So now, without further ado, I want to welcome you to a really exciting program with a terrific author. We are very lucky to have here Dan Canon, who's a civil rights lawyer, a teacher, a writer, a speaker, a consultant, and an activist, who's based primarily in Indiana and Kentucky. He's a professor of law at the Brandeis School of Law and practices with Said and Little. Dan is consistently voted one of the region's top lawyers in the area of individual and constitutional rights. We could go on about his accomplishments for quite a while, but instead, I will emphasize that he is the author of the book Pleading Out: How Plea Bargaining Creates a Permanent Criminal Class, which is now available. And that is going to be, as you know, the subject of today's webinar. We are extremely happy to have him with us today. Hosting this webinar, we are also happy to have NACDL President Martín Sabelli. Again, Martín is someone about whom we could go on forever, but I'll just let you know that Martín received his degrees from Harvard College, the London School of Economics and Political Science, and Yale Law School. He currently has his own firm, but he has served in the past as a federal public defender, a partner of the national firm of Winston and Strawn, the director of training of the Office of the San Francisco Public Defender, and as a law clerk to the late Honorable Robert F. Peckham, United States District Judge. So in addition to being NACDL president, he has a whole lot of other accomplishments. Martín, we are so happy to have you here introducing this. And I will give one more shout out to a fellow NACDL staff member, Nate Pisno, who was instrumental in helping organize this and who has done so much in the way of work on the trial penalty for NACDL. So thank you, Nate. And we're looking forward to your questions and your discussion too as we go along. So Martín, I will turn it over to you. Thank you.
Thank you so much, Vanessa. Thank you, Nate Pisno, for being with us. Thank you, Dan, for being with us. I learned of Dan and his work through our NACDL-led coalition to end the trial penalty. So I want to start out by saying this is part of a larger effort. Today is going to be fun. It's going to be entertaining. We're going to learn a lot. I learned a lot by reading Dan's book, but it's part of a larger effort to take on the trial penalty and eliminate it, not just trim it down at the edges. Nate is a big part of that. He's our procedural rights guru, procedural justice guru at NACDL. And he, together with a bunch of folks at NACDL and other organizations all over the political spectrum, we've created a coalition to take this on, and that's what we're doing. And through that work, I learned of Dan's book. I bought it immediately. I've read it. I read it immediately. Here it is. And I got to tell you, it's top-notch scholarship, but it's also written in an accessible way. And so I thought the greatest tribute in terms of introducing Dan would be to read two pieces of it very, very quickly, because this gives a sense of how accessible and how real this book is. This isn't a piece of abstract scholarship that means nothing. This is about what we do day in and day out in the trenches. And so Dan writes, and this is on page 244, every 6 months or so, a new expose comes out in the New York Times, Atlantic, Harper's, or the like, announcing the final death of the lumbering dinosaur that is the American jury trial. With every new article, the number of trials drops a little bit, and the percentage of plea bargains climbs ever so slightly. And every time the general public treats it like a surprise for a few minutes, but nothing ever changes. It's going to change now, folks. That's why we have Dan, and that's why we have this coalition. And I wanted to read another couple sentences to give you a sense of how Dan's book is really a call to action, not just a retrospective historical exploration of how we got to this miserable place of disappearing trials when the framers wanted us to have trials, but it's a call to action. Dan writes on page 278, so what? So what if there's a huge backlog of cases? And by the way, I imagine Dan doing this like at 1:33 a.m., stomping around his living room, mad and throwing things, right? So what if there is a huge backlog of cases? So what if the courts are so jammed full of trials that they can't function? So what if we can't process thousands of cases a day? The very idea that the US could not bear a shift from a plea-based system to a trial-based system illustrates the whole problem. Why shouldn't a system like that collapse beneath its own weight? It should, but it's not going to collapse beneath its own weight. We have to push it in that direction. And so that's why we have Dan. Dan, it's an honor to have you here. And so we're all ears. Please share your work with us.
Well, thank you so much. And gosh, what a really nice introduction. And it's just a pleasure to be here. I have such admiration for all of your members and the work that you all do. And I'm glad that you're paying attention to this issue. I got involved in it. What most of my career has been 1983 type work, civil rights work, so constitutional litigation. But I've also done a lot of criminal appeals and post-conviction work. And, you know, in looking at the issues that you run into, that all of you run into on a daily basis, you know, what struck me is not only how bad things are in the United States, which I think everybody knows here. You know, we lock up more people than any place in the world for more things, for longer periods of time, more justice-involved people than any civilization in human history, and so on and so forth. But also when you look at what's going on in other countries, you know, what are they doing differently from what we do? And one of the big, as you dig into that, one of the big things that, not the only thing by any stretch of the imagination, but one of the big things that is so different about every other system in the world, including every other common law system, is that nobody has even close to the amount of criminal cases resolved by guilty plea that we do. And so we are sitting, just to sort of frame our discussion today, we're sitting, for those of you who don't know, at about 97% of all criminal cases that get fed into the system are resolved by a guilty plea. And of course, the vast majority of those are the result of a plea bargain. For context, the rest of the world tops out at 80% max, right? And those are the exceptions to the rule. I think the UK, well, Scotland is up around 80%, but Wales and England top out at like 75%, right? You know, India's got a common law system that handles 10 million cases a year, and they resolve less than 1% of those by bargain plea agreements. So we're an outlier in the rest of the world, not only in terms of our criminal justice outcomes, but also in the way that we handle the cases and the way that we resolve cases in the first place. And so I was interested in why that is. And Martín, anytime you want to break in here, please do, because I'll get into professor mode and just like start talking. So please, you know, break in and we'll talk about any of the stuff you want to talk about. But I think to understand how we got to where we are, there are three points in history that we can examine. And one is the 1830s. And in the 1830s, for all intents and purposes, there was no such thing as plea bargaining in America. Just didn't happen. And it was considered illegal even in New England, where it began, up until the 1840s. And I tell a story in the book about a prosecutor in Massachusetts named Asa L. Huntington, who himself was prosecuted, for trying to cut deals to defendants in Massachusetts courts. He got away with it, but that's another story. We think that plea bargaining originated there in Massachusetts sometime during the 1830s, because if you look at, of course, criminal record keeping is not great now. It was even worse then. But if you look at the record, I rely a lot on a scholar named Mary Vogel, who wrote about this stuff about a decade ago. And, she's done a hard look at all the criminal records that we have available to us from Boston during that period of time. And what you see is the rate of guilty pleas on a steady incline. They just go up and up and up starting in the 1830s. But prior to that, it's basically unheard of. So what was happening in the 1830s that would give rise to a system, the system that we now know, something that is based almost entirely on plea bargains and not on jury trials? You have to keep in mind too that, that's a huge shift. Courts were reluctant to take guilty pleas at all for any reason, let alone, just bargain or no bargain. Courts were reluctant to take guilty pleas at that period in history. And all of a sudden this starts to change in Boston and the rest of Massachusetts. And I think if you look at the social and economic factors that were going on during that period of time, it gives us some clue as to why that happened. Post-industrial revolution in America, you've got this enormous population explosion in New England. And in the 1830s alone, you've got a 50% increase in the population in Boston. And so that's big. There's a lot of social shakeups that are happening. Most of those folks that are coming into Boston are migrant laborers from other parts of the country, and of course, lots of European immigrants. And the organized labor movement really starts to take flight during this period of time. In 1834, you've got the first Federation of Labor Unions that forms in New York. So you've got a lot of workers, and they are starting to develop class consciousness. You've got a situation where you've got people in mills and they're living on top of each other in these mill towns, and they're talking to each other, and they're sort of plotting and planning and trying to figure out where the bosses are being unfair to them. And all this is very bad if you're the ruling class, right? If you're the ruling classes in Massachusetts at this time and you see this going on, you want to figure out ways to stop it. And in fact, you see a very concentrated effort by the courts in particular, but an effort by all the institutions in New England society at that period of time to shut down the labor movement, right? And that shouldn't be a surprise to any of us that know anything about 19th century history or 20th century history for that matter. You've got groups of workers that are being prosecuted under conspiracy statutes at that period of time for banding together to try to get higher wages. Well, at that point in time, the courts are saying, well, that's a conspiracy and we're going to prosecute you for that. So that goes on for a little while, for about a decade, until you get to this 1842 case called Commonwealth versus Hunt, which you might have read in law school, but if you're like me, you forgot about it. And it's essentially this case where the Massachusetts Supreme Court says we can't prosecute organized labor just for organizing anymore. Okay, and so what you see along with that is, at the same time, there's this rise. So there's this rash of workers that are coming into New England, and they're developing more class consciousness. And at the same time, in almost every place in the country, you've got universal white male suffrage, meaning that all the working class white men, whether they own land or not, can sit on juries. Not just vote, but sit on juries. And so that's kind of a big deal, right? If you're trying to prosecute all these groups of organized laborers, and you've got those laborers sitting on the jury, those prosecutions don't tend to go very well. And in fact, during the Hunt case and other cases like it, you've got incidents of prosecution witnesses being beaten up outside of the courthouse by workers who are outside and are favorable to the folks that are getting prosecuted and beating them up for what they say is none of their business, right? And the elites in New England are looking at this situation and saying, okay, well this is not good, and we got to do something about this if we want to maintain our place in the pecking order, because at that time, the New England's, the Boston Brahmins and the New England's ruling classes thought of classes essentially being a birthright, right? So there's not enough police power. I mean, there's a recognition by the courts, there's a recognition by the upper classes that there's not enough police power to effectively just step on the head of organized labor and prosecute people for organizing. And so to make up for that, you have the ruling classes using the courts in two really important ways to protect existing social hierarchies. And one of them was to begin taking power away from juries. And until I got into the research for this book, I didn't recognize how powerful juries were back in those days. It's not just the fact finders that we think of now, but the juries were able to say what the law was back in those days. And if I ever learned that in law school, I forgot that too. But not just whether or not the guy ran the red light, but also if it's illegal to run the red light. What are the parameters of the law? That's a terrible example for the 19th century, but you know what I'm saying. So juries are enormously powerful, and something had to be done about that. So that's revoked by judicial fiat and eventually by legislation. If you look back at and I've got some of this in the book, not too much because it would be boring, but if you look back at the Constitutional Convention of 1853 in Massachusetts, there's all this argument over what the role of the jury should be. And, whether or not they should be finders of law, and whether or not it's a good idea to just turn the law wholly over to judges, which is something we just sort of take for granted now. Well, by 1853, the jury's function has been radically diminished in New England, and the other states sort of follow suit with that. And juries are just fact finders. And there's also this effort to make cases more opaque and to keep evidence from juries and to, basically make it into the kind of system of jury trials that we know now that are not super accessible to working class or uneducated people. So that's one way, is just by outright taking power away from juries. And the other way, and what I'm arguing in the book, is by instituting a system of bargain pleas to replace the jury trial, because jury trials were just simply too dangerous, right? So think about this. 1830, the plea bargain is essentially illegal in Massachusetts for all intents and purposes. By 1850, 50% of all criminal cases are resolved via guilty plea. By 1880, that number jumps to almost 90%. And one of the things is, it's just incredible. It's almost a total takeover before we even hit the 20th century. And I don't want to get too much on an aside because I'll forget what I was trying to talk about here. But, one of the things I talk about in the book is that we've really not ever tried in any earnest way to institute a system of citizen juries that would look anything like a jury of one's peers, right? So you have universal white male suffrage happening sometime around the 1830s. And then by the 1880s, there's no jury trials left to speak of in Massachusetts. Women did not get the right to sit on juries in Massachusetts until 1950. So that's 70 years after you've got, a 90% plea bargain takeover in Massachusetts. And to say nothing of people of color and other folks who were, systematically excluded. We didn't have a case from the Supreme Court that said you couldn't systematically exclude wage workers from the jury pool until the 1940s. So a jury trial, in any sort of broad sense, that is truly composed of a cross-section of the community has not really ever been tried, certainly not in New England and not in the rest of the country. So why is the plea bargain so important for maintaining the social status quo, because it excludes the jury, right? It excludes the jury from the whole process, and thereby excludes the public, and thereby excludes the working classes from the entire process of criminal justice. And that was a good thing to the ruling classes at that time. So what they do, instead of prosecuting groups of workers directly for organizing, which they can't do anymore, they knew that was too risky of a proposition, is to switch to prosecuting each individual worker under vagrancy statutes, under drunken disorderly statutes, under the, whatever sort of broad statute that they can come up with. And they're grabbing all of these guys and they're prosecuting them for something or other. And the state is able to somehow keep an eye on them. But, the more important thing is that they're creating lots of criminals that then go back to their communities and become pariahs because they're criminals. And that crumbles the cookie of working class solidarity. At least that's my theory in the book.
And can you draw parallels? I'm sure you're going there, but can you draw parallels between what you've just explained, the legislation of morality and the enforcement of a kind of morality to ostracize or isolate people in the 19th century, with what happened in the war on drugs in the 20th century? Yeah,
for sure. Well, and I'm getting there. So, by the time, well, just to jump ahead, by the time we get to the mid 20th century, so much is criminalized that, you have this total removal of the public from the justice system. And so many things are criminalized that don't really have anything to do with the mores of the community, right? That don't really have anything to do with, what is culturally disapproved even. One of the sort of chilling things that I get into in the book is I talked to a couple of state senators and other state legislators for this book. And I've asked them about, what amounts in some cases to monumentally stupid pieces of legislation that they've signed off on. So I talked to one Indiana state senator who I knew would shoot straight with me. And I'm like, look, why did you vote for this bill that sort of uber criminalizes trespassing? And some of you may know this if you're in red states, because this piece of legislation is just this ALEC monster that ripped through about 8 or 10 red states a couple of years ago. And it just imposes this ultra fine and sometimes prison time for trespassing onto what they call critical infrastructure. So now in Oklahoma, for example, you can be fined $1 million for trespassing onto critical infrastructure. Of course, this is meant to stop people from protesting on oil and gas pipelines, right? Which we don't really have in Indiana, but yet we have one of these bills. And here it's $100,000. So, and it extends so far as to, if somebody on Facebook creates a Facebook event that says, hey, let's go protest this pipeline. And the organizer doesn't show up for it, but I do, and I trespass onto critical infrastructure. Well, the person that set up the Facebook event can be fined $100,000 or $1 million in Oklahoma, right? So this profoundly stupid piece of legislation that is just a dead giveaway to the oil and gas industry. And so I asked this state senator, I'm like, why did you vote for this? He's like, oh, we don't read those. This is a thing that I was not in the committee hearing for. And when it came to the floor for a vote, it's like trespassing onto critical infrastructure. Well, that sounds pretty good. Why not just go ahead and sign off on that? And I argue that this is a byproduct of totally divorcing the community from the process of criminal justice. And, everybody that I talk to confirms that there's this sort of ram and jam of criminal legislation. So you have all this stuff that's out there. Nobody even really knows what's criminal. So you can just sort of, and everybody on this call knows, you can just sort of assume that anything you do is a criminal action that they can come and get you for. And what is it? Harvey Silverglade, I think, that says you can sit at your computer and commit 3 felonies a day without even knowing it. But that is a direct result of the next period in time that I wanted to get into, which is the Prohibition Era. So you have this ramping up. And by the way, the prohibition movement starts in earnest in the 1830s, which I think is really interesting. So you have all these different, social changes that are going on in the 1830s. The rise of organized labor, the recognition that they can no longer criminalize organized labor, and the rise of the plea bargain and the taking away of power from juries and universal white male suffrage. You could think all that is a coincidence, but I really don't. And then if you look at the next historical flashpoint, right around 1920, when prohibition really takes hold and the Volstead Acts go into effect. And there you see from 1920 to 1933, the federal government get involved in criminal justice in a way that it had never been involved before. And all of a sudden they're all in with agencies and with, sweeping new sections of the criminal code and everything else. And between 1920 and 1933, you've got a tripling of the number of prisoners that are in federal custody. So it's a lot. There's this enormous expansion of the criminal law. And you've got this spoken sense of urgency now driving criminal justice. And Herbert Hoover says in his inaugural address that expediency, over and over, due process is very nice, but what we really need to do is lock up lots of people, and we've got to do it fast. And he says it over and over and over again. It's not just the bootleggers that we're trying to lock up, but it's the people who assist the bootleggers and the people who assist the people who assist the bootlegger. And so they make it pretty clear that we're going after everybody. Everybody is somehow involved in some sort of terrible crime at this point in time, and we're going to go get them all. And we can't do that without a mechanism for doing it. We can't create all those criminals, and we can't get all the convictions we need. And gosh dang it, we just can't round everybody up if we're going to lean on jury trials, right? And even after prohibition goes away, of course, the feds stay in the game. The year after prohibition goes away in 1934, there's 9 federal crime bills that are passed. And you've got the new AG coming in and saying, I can't remember his name. He comes in and says, well, now our big challenge is illegal narcotics, right? And so, the rest of the states, of course, the states are following suit, and they're essentially, getting in on the war on alcohol and then subsequently the war on drugs and criminalizing everything under the sun, and police power increases every place. And all all the rest. To get to your question, I told you I was going to be long-winded about this stuff. You get to the 1970s. And throughout this time, you've got this ramping up of the criminal law and, super arming of police officers. And if you haven't read Rise of the Warrior Cop by Radley Balco, it's a great book. You got to read that one too. As somebody who's litigated, 1983 cases against SWAT teams who will just kick down a door at the slightest possible suggestion that something's going on. But I digress. So all that is ramping up during that period of time. We're locking more and more people up. And the guiding principle is still expediency, expediency, expediency. But the academy and lots of lawyers and judges are not really sure that this is a great thing to do. And there is still some public conversation up until, the late 1970s. I think it's in 1973 that you've got a National Commission on Criminal Defense that recommends that all plea bargaining be done away with by the year 1978. Mm-hmm. So it's hard to think. It's hard to imagine that now. You suggest something like that, and you're just, going to be laughed off the planet.
Let me jump in for half a second here.
Yeah.
We had our trial penalty summit, a roll up your sleeves kind of event in December with lots of organizations designed to work out solutions to the trial penalty problem. And the person who put this issue of getting rid of plea bargains totally on the table was an elected prosecutor from Utah. So they're somebody who characterizes himself as a right-wing Republican.
Great.
And so there are voices now who are coming back to that. I'm sorry, Dan, go ahead.
No, it's okay. And I think that you've hit on something important here. This is an issue that's important across the political spectrum. You said it at the very beginning. And the folks that I interviewed for this, I've got people that are socialists and people that are red hat wearing, make America great again, Trump guys, former prosecutors that are all on board with, restricting the power of the prosecutor in some way. So I think that is that is somewhat promising. I'm relying on my own experience here where, pretty much every conversation that I've had and what I was taught in law school is that, plea bargaining is a necessary evil, that we have to do things this way or the whole system is going to crash and we're just not going to have a criminal justice system anymore. And it's going to be cats marrying dogs and chaos and pandemonium in the streets. And it turns out that's not true. And I'll get to that. But in the 1970s, so as you know, plea bargaining did not go away in 1978. What happened in 1978 is this case called Borden Culture versus Hayes. And this is not a case that we teach very much in law school, I don't think. But I'll tell you what happened in it if you don't remember. Paul Hayes is a guy from right down the street here in Lexington. He's a black horse transporter, drives horses around the state of Kentucky. And Paul gets busted for writing a bad check for $88.30 at a Lexington grocery store. They arrest him, put a gun in his face, arrest him right there on the spot. And Paul had caught another charge about a decade earlier. So the prosecutor comes to him and says, listen, you're not gonna make me go through a trial here. What you're gonna do is you're gonna take 5 years. Paul's like, I don't want to take 5 years. This is an $88.30 check, and I got a job and a family and all that stuff. I don't want to take 5 years. The prosecutor says, well, if you don't take 5 years, I'm going to smack you with this habitual offender charge, and you're going to do life because that's the mandatory sentence in Kentucky at that time. Paul says, no, thank you. I'll take my chances with the jury. And wouldn't you know it, the jury convicts him, and he gets life in prison. Well, I talked to Paul's lawyer that represented him at the Supreme Court. There's a guy that practices right down the street from me named Vince April. Just, hero lawyer as far as criminal defense lawyers go. One of the best in my view. And I talked to Vince for a long time about this. And he said something that surprised me, is that he got letters throughout the course of doing that Supreme Court case and doing Paul's parole application, which he also worked on. He got letters from prosecutors all over the country saying, that is outrageous. I just can't believe that a prosecutor would threaten somebody with these habitual offenders, with life in prison just for exercising his right to a trial. I just can't believe that. And I would never do such a thing. And, well, folks, I don't know if those prosecutors were telling the truth. He included all his materials in Paul's parole application. But I don't know if those prosecutors were telling the truth, but it scarcely matters now. Because I think everybody on this call knows that that's pretty much business as usual. They're going to use whatever carrot and whatever stick. And well, it's this Borden Culture case that really allows them to do that. I think it's a turning point in American history, where the court there says that it's the prosecutor's job to persuade a defendant to give up their right to trial. This is what this prosecutor said in that case. You look at the trial transcript and he says, well, isn't it true? He puts Hayes on the stand and says, isn't it true that I told you if you put the court through an inconvenience, the inconvenience of trial, that I was going to hit you with these habitual offender charges? And lay people read this story and they're like, what? That's ridiculous, right? And for us, it's business as usual, and at least, it always was that way for me. And, that's, I think for 2 generations of lawyers now, we've sort of accepted for the most part that this is the way things are going to go, that the prosecutor is going to use whatever tool and they're going to be able to do it and they're going to get away with it. And so that sort of throws open the Borden Culture case sort of throws open the floodgates for, everything that all the ills that we sort of experience now. And the plea bargaining rate nationwide was enormous at that time, and continued to get higher and higher and higher and higher. And I'm not going to remember the exact statistic off the top of my head, but I mean, there's something like between 1962 and 1990 something, you've got this enormous increase in the amount of actually, maybe I have it in my notes because it's such a shocking statistic. You've got this enormous, 15% in 1962, 15% of all federal cases went to trial. That's 5,000 cases. So just 15% in 1962. And by 1997, the number of actual trials had dropped to 3,200, just over 3,000. So that's fewer actual trials, even though you've got an enormous increase in cases. So not only has the percentage of cases going to trial gone way, way, way down, but also the raw number, it's gone down so much that the raw number of trials every year has gone down between the years of 1962 and 1997. And I think a lot of that is driven by the court swinging open the doors in that Borden Culture decision. So it's a very long way to answer your question.
And Dan, does this have a snowballing effect in the sense of, because trials are fewer and fewer, less and less frequent, judges get more and more pissed off, and there's a role that we should talk about judicial complicity, not just prosecutors.
Yeah.
Judges get more and more pissed off when somebody makes them sit in the courtroom all day long and have to make, rulings on objections instead of doing what they want to do. Prosecutors get more and more scared, and they're more and more angry when they're forced to give up weeks of their life. And we defenders, we have to take something on our shoulders as well. We become more rusty. We become less used to going to trial. It becomes less part of our culture, less part of our way in the world, and we were less confident in our skills, and maybe we project that a little less to our clients. I don't know. I think
that's right. Yeah, I think that's right. Trials are hard, right? Anybody that's ever tried a case, a jury trial is tough work. It's hard work. And so I think there is a natural pull to just, avoid it if you possibly can, right? And the prosecutor's got all the tools in the world to be able to do that. And defense attorneys, of course, can twist arms too and say, listen, you really better take this deal because you're not going to get anything better. And the prosecutor holds all the cards. There is, and you mentioned judicial, the judicial accomplices. And there was a case out of my home circuit that maybe some of you saw, came out the last couple of weeks, where it's interesting now because the judiciary over time has done an about face, and even the appellate courts, that used to be super suspicious about this stuff. And really, this happened in the 20th century. Appellate courts and state Supreme Courts, especially, used to be really suspicious about plea bargaining overall. But they would, generally speaking, never see the cases. And now, when in the rare event that they do see a case involving a plea bargain, they're just increasing the power of the prosecutor. So we have this case out of the Sixth Circuit here recently, where a judge says, it is not my practice to accept a bargained plea where the defendant has agreed to give up their right to an appeal and their right to any post-conviction remedies, which is this cute thing that federal prosecutors are really trying to do now. And the Sixth Circuit says the judge can't do that. Like, the judge can't set the parameters of the plea deal, which is just incredible. Now, look, the Sixth Circuit, those folks are monsters, but my God, that is really just outside of the bounds of anything that I would have ever thought that even that circuit was capable of. And it gives so much power to prosecutors, but that's essentially where we are. You see these, sort of monstrous cases where, in the early 20th century, for example, any sort of restrictions on reproductive rights as part of a plea bargain, if those got to the appellate court, they were like, no, you can't do that. Now, if it happens, pretty much what all the state courts are saying is, well, this is part of a bargain agreement and we're not going to get involved in it. You just
mentioned the Sutton case, which coincidentally in the Sixth Circuit, which I just filed a brief on in the Ninth Circuit, I expect to get my head handed to me tomorrow because I'm criticizing a judge for rejecting a plea bargain in our case. In that case, the judge was actually not being complicit in the trial penalty. The judge was saying, you can't use your power that way. That is wrong, prosecutor.
Right.
You cannot twist somebody's arm if there's an appellate issue. the appellate court should hear it, and the appellate court said, no, prosecutors have that power to coerce whatever they want. And there is some contrary case law, but there ain't much of it. And what's happening across the board, and I'm going to come in for a landing here with my question, is that I think that and this really dovetails with the recent confirmation brouhaha over Ketanji Brown Jackson, that we just don't have judges who've ever been in the trenches, who don't understand that the trials are actually disappearing, and they don't understand the power of the prosecutor, especially in state systems, but even in the federal system. And if you get a judiciary that is essentially purified or purged of people who've been in the trenches, the judges don't even see the effect.
Yeah, well, and I've seen it here at the law school. Is it possible for somebody to go all the way through law school and really just sort of, skim their public service requirements, whatever that might be, and, do something that is kind of remotely related to legal work or work for a judge or something like that, and really have no contact with the criminal justice system? Sure. And then they get into practice and it's big firm life, or it's clerkships and then big firm life, or whatever. And that puts you on track to, the folks that have the connections to be placed on the federal judiciary, or even to run for state judge in many cases, but the folks that are just sort of plucked out of these big firms and say, okay, you're a judge now. Many of those folks, most of them, almost none of them have been public defenders. I think the number is like 7% right now. And almost none of them have represented a human being in court. Is it possible to go an entire career without representing a person in court? It might sound alien to the people on this call, but of course it is. And you and I were talking the other day. I'm not sure about this, but I think that KBJ is the only justice currently on the court that's ever represented a person, like an actual person in court. I'm not 100% sure about that, but it is a rarity.
I think John Roberts was involved in a capital post-conviction representation, but I think you're right.
Yeah, which is different, of course, than than somebody that's got a history of public service like Ketanji Brown Jackson, and who is, as you say, in the trenches. I mean, it's a totally different thing, and I think it causes you to look at criminal justice in a totally different way. But I would venture to say that most of these folks that get on the bench, their first experience with criminal justice is when they have to sentence somebody. And that's terrifying. Everybody should be scared of that.
So Dan, where are we? Are there legal strategies in individual cases or reform strategies that you think might be promising? What do we do as individual practitioners? There's the old Alice's restaurant. One person, you're crazy. Two people, you're a conspiracy. Three people, you're a movement. So what can we do to push back on this in an individual context when I'm representing a person, or as part of NACDL or other criminal legal reform organizations?
That's tough. It's tough because the problem is so intractable at this point, and it is, is really become fundamentally a cultural problem. And where everybody expects that a case, 97% of your cases, really all of your cases, are going to end in plea deals. And so, what you've got your eye on as a defense attorney, well, and as a prosecutor too, is what is the best way to end this with a plea deal? And I think that most defendants that are justice involved people, if they have any experience within the system, go in thinking, what is the best deal I could get? I think that there is a big role for prosecutors to play, obviously, and in some ways, I think the best thing that individual lawyers can do is to run for prosecutor, because the prosecutors really hold the keys to the kingdom here. And I mean, I don't know, I'm sure we'll get to this eventually, but it is historically in the United States, when there's been a change in plea bargaining practices in a region, in a jurisdiction, that has been brought about by a prosecutor at some level, right? For the most part. So you've got the example of Alaska in 1975, where I talk about extensively in the book, where you've got an AG that comes in and he controls all the stuff that's going on the ground in Alaska. He says, all right, no more plea bargains. They all got to come through my office. And all of a sudden trials go up by a bajillion percent. And what happens there is that the system doesn't crash, but it becomes more intelligent, you know? And I think that's the principle to keep in mind when we're trying to approach, you know, a way to resolve the problem, is that, you know, reject that idea. And you read that passage from the book. I mean, okay, the whole system crashes, and maybe that's not the worst thing, but I think we reject the idea that the system crashes if we do away with a small percentage of the plea bargaining. If we do away with 10 to 20% of plea bargaining, you know, does that crash the whole system? Well, no. I think what we've seen historically is that the system becomes more intelligent, and that's what happened in Alaska. All of a sudden, the prosecutor's offices go from rejecting 4% of all the cases that Alaska cops are bringing them to rejecting 44%. And this really, and I talked to a lot of the Alaska public defenders that are around at the time that happened, that really was chapping their hides to avoid a crude idiom. No, I mean, like, it was not something that they looked upon very favorably, and the police hated it. And so this is where you get this, you know, sort of cultural resistance to it, but it does make things better. Ultimately, what you see happen is that the Alaska police know that they're going to be put under a microscope. They know they're probably going to have to, you know, get in a box, and they're going to have to testify, and they're going to have to, you know, show the goods. Which right now they know they're going to make an arrest, and the prosecutor is going to convict on something, so I'm going to get away with anything. I got all kinds of horror stories in there about that, and you know these. But instead, you know, so the prosecutors and the police are doing this for a little bit, and then, you know, throughout the course of 10 years that Ab Gross was in office, it sort of smooths itself out. So there's a lot more trials, but there's a lot fewer BS prosecutions. And that's a big deal. Same kind of thing that happens in New Orleans. You've got a lot more case screening going on by prosecutors, and a lot more cases that were trash cases that just get dismissed outright by Harry Connick Sr.'s office. So we don't really have a precedent for saying that the system will crash if we increase it by 10 to 20%. And so all that is to say that if I'm in charge of a public defense agency or some sort of organization, which thankfully I am not, but if I were, I think that I would, you know, shoot for, let's try for an increase somehow, by hook or by crook, in a targeted area, one little county. Let's pick that county and say, let's increase jury trials by 20%, you know, by X date. Let's do that. Let's see if we can't do that. We'll figure out how to do it. Go ahead.
Yeah, I mean, that's the tough thing for leaders of offices, because there's a tension between what might be good for the clients coming down the line, as opposed to this particular client. And obviously the lawyer, she or he, has to worry about this particular client. But if we don't change the landscape, if we don't change the field, you know, the field is tilted against us. So we've got to figure out a way to do that. Let me draw out a little bit that pulled a string on something you said before about police misconduct. It's something that we've seen across the board, that the police officers know they're never going to be subject to a cross-examination in a pretrial hearing or trial, because these pleas require waivers not only of the right to trial, but all of the rights in the Bill of Rights, including, you know, the right to be free of unreasonable searches and seizures. So police officers, sometimes intentionally, maybe sometimes just because of this cultural creep, they do what they want to do on the street because they know they're never going to have to answer for it. And so there's a direct link between the trial penalty and police misconduct, which is something that you know, that we see as defenders.
100%. Oh yeah, go ahead.
And I also want to say that one of the things that happens in response to this that we've seen is that what the police and the prosecutors do is they tack on a resisting arrest charge to a ridiculous charge, like, let's say, wearing loose, you know, selling loosies like Eric Garner died for, or wearing your baggy, you know, pants below your butt as I can't remember the name of the gentleman who died in Louisiana being arrested for this. And then they tack onto that resisting arrest charges to make it more legitimate. And then that gives the prosecution a bargaining power that they otherwise wouldn't have with the original charge.
Yeah. Yeah. I mean, it's a big problem in terms of policing. If you send police, like, let's say you send all that you said is true. And then think about this other dimension too. You send a racist cop out into the world, and only they know their own motives. And they know that whatever they do, if they want to go out and arrest all the Black people for, whatever minor crime, and only focus on Black folks, they can do that. And they know they're not going to be really accountable in any way for doing that. And they know that they're going to be justified because the prosecutors got all the power to make sure that each one of those arrests ends in some kind of a conviction. Or at least something that never ends up with the cop under a microscope. And I think too that, along with, this is why it's so critical for lawyers on the ground to understand the big picture. And I mean, it's hard because you're trying to represent a single client and you got to act in that client's best interest. But there is also this big picture that we miss because, it feels like a job. And you go in, you're like, all right, I'm going to do my job. I'm going to do the best I can with this situation. And, but so there's this bigger umbrella that we tend not to be able to see. But it's not just a policing issue. It's the issue that I mentioned about the divorcing of the community from the whole process of criminal justice, which leads to terrible laws because nobody pays any attention to the criminal laws, including the legislature. But there's also this bit that I discuss in the book about the participation theory of democracy. And I mean, juries are still immensely powerful. Even now, it's probably the most power that most citizens are ever going to have is when they are able to sit in judgment of somebody on a jury. And we've convinced ourselves that it's an albatross, that it's boring. I get calls every week, like you all do, from folks I went to high school with that want to figure out how to get out of jury duty because it's such a drag. And we've talked ourselves into this place where, we don't want to exercise that power. And, it's very hard for the working classes too. I mean, we pay jurors $12 a day here, so that's tough. But it's become this thing of, there really are no jury trials and therefore no citizens exercising this core democratic function, which is the most that most of us will probably ever participate in our democracy. And the participation theory of democracy is this poli-sci thing that says, if you participate a little bit in a democratic process, like voting, which, I mean, for most people is show up, see who's on the ballot. I like that name the best. You tick the box and you go. Maybe you do a little bit of research before. But if you participate a little bit, then you're going to care about your democracy and your community a little bit more. But if you participate a lot in something that requires a lot of deliberation, then you care a lot more. And study after study after study shows this. And the single most deliberative thing that you can do is to sit on a jury as a citizen. And no one's doing that, certainly not a cross section of the community. One of the shocking statistics that I've got in the book is from this study out of Texas. It says, of the people called to jury duty in metropolitan areas, only about 20% show up. And those 20% are the people who can afford it. They're, people who are upper middle class white people. Now, nothing against upper middle class white people. I am one. But, if that's the only folks that are sitting on criminal juries, you do not have an adequate cross-section of your community. And when judges try to do something about this, they get smacked down. As we saw in the Sixth Circuit, I've got the story of Olu Stevens from here in Louisville, who, would not seat all white juries to sit in judgment of Black defendants. And the state Supreme Court suspended him for 90 days and said, actually, you're the racist judge. So it's a tough problem. It's a tough and intractable problem. And I think, to get back to your original question, the single most important thing we can do as individual practitioners is simply to educate our clients that they have something else they can do, like that they don't necessarily have to go and plead, that they can go to trial, and to present that as a real option. But for the most part, I think that this work is better done at the grassroots level, and by reform organizations and by people putting in shoe leather and knocking doors and building coalitions and that kind of thing. And the whole last chapter is profiling people that have been able to swing public opinion on criminal justice issues by doing exactly that. So we look at activists in Wisconsin and in Florida and in Louisiana, and then try to come up with a formula for the successes that they've had out there and apply it to the trial penalty issue, to the plea bargaining issue, which is basically to get it into people's head, like, wait a minute, let's be suspicious about taking whatever plea comes to you, right? And let's be suspicious about that, and let's recognize that we have a right to go to trial.
And obviously, one of the things we need to do on the defense side is train our lawyers so our lawyers are confident, and make sure we have the resources to investigate, so our lawyers are confident and can flag a factual issue and pursue it. Dan, there are a whole bunch of questions. Let me pose some of the questions because they're piling up here.
Yeah, please.
One person says, excellent presentation. If you will, please comment on the ethics of a trial judge who requires the parties to disclose the plea offer when the defendant has rejected the prosecutor's offer and seeks to go to trial. Obviously, there's a Rule 11 concern in the federal system, but speak to that issue if you can.
Well, let's see. Let me look at that. I want to read that question back if I can find it.
Yeah, that's from.
Yeah, no, I see it.
Yeah.
Yeah, well, this is sort of what we ran, what that Sixth Circuit case that I mentioned before is dealing with, where if a judge tries to wade into it, even by setting parameters. And I think it's one thing where if you have a judge that says, listen, let me know the details of this deal, and if I don't like the way you went about it, then then the judge becomes a negotiating party, and that's a problem. But I think that if a judge is simply, what we're seeing is when a judge simply sets parameters for what kinds of plea bargains are acceptable, courts are saying you can't even do that, right? So I don't know about I don't know if I'm answering your question here, and I don't know about the rules in Texas. I'm looking back over this again. Martin, what are your thoughts on that?
My thoughts are that I could imagine a situation where it's done in the right way when requested by defense counsel. Sorry, my dog was scratching at my door. I had to go get her. So I could see a way that would be framed as part of an evidentiary request on the part of the defense to demonstrate that the prosecutor is trying to coerce a plea bargain by asking for a heavier sentence after a plea bargain has been rejected. But I think that if the judge does it sua sponte, or if it's at the request of the prosecution, I think it's another manifestation of the trial penalty. It's saying, that would be a hallmark of judicial complicity in the trial penalty. Look, I want to know, what you rejected so I can give you something higher. And so I think if it's at the request of the defense, in order to prove that there's been unconstitutional coercion, I think it's fine. But otherwise, I think it's a major problem. And the problem with Rule 11 in the federal system is we're not even allowed to do that. We can't litigate that because Rule 11 in the federal system keeps you from doing that. I think, it hasn't been tried too often. I see Nate jumping up there. Nate,
jumping in. We've seen proposals, for trying to mitigate or ameliorate the trial penalty where that would allow the, a sealed, pre-trial plea offer to be reviewed by the judge at sentencing in order to ensure that a sentence is not higher, or at least as close to what was, presumably the much lower offer pre-trial. But it sounds like Bobby's question is sort of the flip side of that coin. And I agree with Martín that that's, I think that can go both ways, whether judges are involved and how and when is, it's a tricky issue, and it can be, obviously judges are often complicit in the trial penalty, but I think they can also be help to guard against them in some cases.
I mean, I would say that I would like to have more of that, more of the negotiations sort of in the light and available for higher courts, but as I was saying before, the higher courts really at this point don't seem to care all that much. In the rare instance that they get there, that these issues get there at all, the court is just going to rubber stamp whatever the prosecution wants to do.
So. Because, and this is a theme in the questions, and I want to come to a couple of them, because the plea bargaining is framed as a benefit to the defendant in a system in which we have these outrageous sentencing guidelines and outrageous mandatory minimums. So why are you complaining? You're getting a benefit. You're not being charged with a mandatory minimum. Well, but if you're in this really toxic ocean, it's not a benefit. It's just the worst. It's the worst of. It's the better of two evils. Yeah. So I want to come to a question from Doug, and isn't the issue really with draconian mandatory minimums and obscene sentencing guidelines? Unless those are fixed, the plea system will always remain coercive. The other big issue to tackle is bail reform.
Yeah, I think so. But I mean, even in jurisdictions where you don't really have an issue of mandatory minimums and there's no sentencing guidelines to speak of, you still have the problem of the prosecutor being able to whack somebody over the head between, what's the difference between attempted murder and, assault for or wanton endangerment or something like that, right? So, if you're letting them charge these cases, if you're letting them engage in whatever sort of unfettered charge bargaining, I mean, you're going to run into this no matter what the legislative code looks like.
That's right. And the tail end of what Doug is saying is bail reform. And that is so true. Having people sit in custody breaks their will, makes it impossible to work with their lawyers, makes it impossible to investigate, and they plead.
Yeah. I mean, it is, as I said, it's a logjam. It really is. And when you have somebody that is locked up indefinitely, and this is the kind of thing that as a practitioner, you can't really allow to happen. If you've got a deal that's on the table, you got a client that wants to get out of jail. I mean, you have to take the deal. I think those are not the kinds of cases where, at least initially, you're going to be able to marshal an increase in trials. The bail issue has to be dealt with, of course, but you're talking about, yet another tool in the state's arsenal to coerce somebody into a plea deal, and they've got all of them.
Dan, I have a very specific practitioner-oriented question that I'm sort of stealing from David Frank. NACDL has done a lot of work on clemency, and one of the aspects of our work has been to point out where somebody was hammered in a particularly brutal way by the trial panel, and as a one argument for clemency. And so David asks, are there data analytic efforts underway that will enable criminal defense attorneys to, quote unquote, make a record most effectively as to the underlying biases and inequities at work here? In other words, if you're, can you look at it at a system level, but also as an individual lawyer, if you see your clients being hammered, how do you make a record so that somebody 5 years later or 10 years later can seek clemency or seek some sort of relief and say, my client shouldn't have gotten life, my client shouldn't have gotten 20, he or she was hammered by the trial panel? What can you do in the trenches to make that record?
I mean, I wish I had a good answer for that. As somebody that's done post-conviction for 15 years in Kentucky, I mean, it's virtually impossible, if I understand the question right, to get the courts to pay attention to this. When someone has taken a guilty plea, it doesn't really matter how much coercion has gone on. And is somebody keeping score of, I mean, that's, and this may be, I may be missing the question here. I mean, is somebody keeping score of all the, various injustices that go on in the plea bargaining process? I mean, I think the answer to that for the most part is no, and certainly not in my part of the world where there's just no, criminal justice advocacy organizations that would be tasked, that would be able to do that. And I think it's true for most of the country. I mean, there's the New Yorks and the LAs of the world But for the most part, all this stuff is just like going on at light speed. There's not much record of it. And the whole problem with, part of the whole problem with plea bargaining to begin with is it just creates no record and leaves no trace. If something unfair happened, you don't know.
And so I think the thrust of the question is, even though you may feel as a lawyer that your client is probably going to take a plea or is going to take a plea, you know it, we can build a record along the way that is internal, but also possibly external. For example, doing a whole sentencing presentation, even where there's a conditional plea, even where the plea is basically, the plea is fixed, so that someone down the line can come back and say, you know what, this really wasn't a fair sentence. This person was coerced.
Yeah.
And sometimes you even get a judge to say, I don't want to apply this mandatory minimum. I have to do it. But I think, and NACDL, by the way, is doing trial penalty studies in many states, and we're hoping to do it state by state across the country to make a record of this, of how this is happening state by state. We've already done it on the federal level. Vanessa put the link already in the chat. But on an individual level, in an individual case, I think we can pepper our file with evidence of why this was coerced.
Yeah, well, and I think that, as much light as you can possibly have on the process, the better, because essentially right now there is none. But I think this is a better question for you, Martín, and for the trench lawyers that are out there. I'm not doing it on a day-to-day basis. So,
and let's see there. Lisa Wayne, our executive director, adds to this. Dan is correct. The defendant who goes to trial and loses is always sentenced more harshly than the defendant who pleads, no matter what the mandatory minimums are. So Dan and Lisa are right that it's a cultural issue beyond simply the one tool. The mandatory minimum, in my view, is the one tool we ought to focus on and get rid of, because it's the most powerful tool in the hands of the prosecutors to coerce plea bargains. But the issue is it's much deeper. It's a cultural one. And so I agree, we need to take that on.
And one that none of the rest of the world does. To go back to the beginning, I think if you look at guidelines for prosecutors in Australia and in the UK and other common law systems, they're not allowed to engage in sort of unfettered charge bargaining in the way our prosecutors are. And we've just decided we're going to turn it all over to the prosecutors.
Another listener, Lisa Wilt, asks, is there a way to quantify statistically that defendants receive more appropriate judicial fairness by increasing the ability of trial versus plea bargaining? Can we quantify that statistically?
I mean, at this point, in a broader sense, I would say no, because again, we've never really tried any sort of broad scale jury trials, right? To my way of thinking, we've never really done that in the United States. There is some data in there in the studies from Alaska about what juries do versus what the outcomes would be as a result of a plea bargain. But I think that the data is, for the most part, unreliable because, well, for a lot of different reasons, but mainly because we're not talking about real citizen juries. We're not talking about real juries of one's peers here. So you guys may know of some statistics. I don't have anything floating around in my head, but I think that in general, when these studies have been done, what's sort of like chewing at the back of my brain here, and I'd have to go back through my notes, and maybe it's somewhere in the book, I don't know, is that the outcomes are really not a whole lot different, right? Again, I don't know how reliable these studies are, but the outcomes of, for example, if somebody does an open plea, and I'm starting to remember now, I think if somebody does an open plea, from the Alaska studies, the open pleas were not like, the judges are not going any easier on, say, for example, rape defendants than they are than the prosecutors are. So the outcomes seem to be roughly the same. It's just that there are fewer of them. What do you think about that, guys?
I think you're. Go ahead, Nate.
No, go ahead, Mark. Well,
no,
if you look only at sentencing, I mean, there's probably several measures of judicial fairness, which is what Lisa asked about in her question. But in our federal trial penalty report, we basically prove that defendants that do plead guilty are getting a third of the sentences, I think, on average, than folks at the federal level, at least, who are convicted after trial. And there are, I think it's figure 1 of that report, which is available online, and I think Vanessa linked to it. In sentencing, I think that is statistically proven. As far as other aspects,
that is a guideline problem, though, isn't it? I mean, at the federal level, because you've got somebody that's getting hammered for being untruthful or whatever because they decided to go to trial. So.
Yeah, they don't get the acceptance of responsibility. I mean, there's all sorts of little guideline things that do come into play.
It's worth mentioning that the hammer is harder on what are typically characterized as street crimes, in part because there are mandatory minimum sentences in that context at state and federal level, not really for the quote unquote white collar crimes. So that the street crimes, which are generally prosecuted against poor people and people of color, are hammered much more brutally after trial. And I think it's a good moment to raise the notion that systemic racism and implicit bias come in here as well. I mean, I've had clients look across at me at the table and say, I'm going to get an all-white jury, or their jury's not going to listen to me. And there are clients of color. And so their understanding of the trial penalty and what's going to happen to them after trial is in part based upon their very proper understanding based on life experience of what it is to be a person of color in the United States. And I never have an answer for that with my clients.
Yeah.
And by the way, and it comes in terms of the way the prosecutors frame offers as well. Somebody asked about framing prosecutor offers, but subjective bias, implicit bias comes in as well in terms of how prosecutors, what offers they give.
One of the troubling things that I'm now remembering from the Alaska study is that when people went to jury trials on theft crimes in particular, like everything else, the outcomes didn't really make that much difference. But when people went to jury trials on theft crimes, they were getting hammered harder by the juries. Again, if you don't have enough jury trials, you're not getting enough of a cross-section of the community. And you have to, there's fixes that need to be applied to the jury system and to the bail system and to every other kind of system. And so it's a problem. But I think generally speaking, more trials is better. And part of what I'm arguing in the book is that it can't possibly be worse.
I want to bring in another issue, and that is the issue of economics. Across the country, for example, right now, Oregon public defenders are overwhelmed, and that's not unusual, in terms of the number of cases. In New York, until recently, there was I can't remember what it was, a very fixed low fee, maybe $700 for a felony case. And if the economic infrastructure for trying cases is not present, you can't try cases.
Yeah.
Is that part of the problem?
Yeah, you're talking about on the defense side, like
on the defense side for whether they're court-appointed counsel or public defenders, or even retained lawyers who are looking at the enormous, their clients are looking at the enormous costs of going to trial. Is that not also part of the problem, that to defend a case, we don't have the economic resources as a nation devoted to that?
Well, that is what I would say if I was on the side of more trials will crash the system. You know what I'm saying? I think this is a problem for private defendants, but defendants that don't have a court-appointed lawyer are about 5% right now. Mm-hmm. It's just almost nobody. Which, by the way, creates a problem for, as all of you know, for the folks that are in private practice, for folks that come out of the public defender's offices. And I certainly see it in my town. You got folks that come out of public defender's offices and try to hang a shingle. And then there's, all these great criminal defense lawyers that are sort of competing for the last remaining 5% of the defendants that don't have the right to appointed counsel. But I digress. I think that there's a quote in the book from Justice Berger, I think it is, who says that if you raise the number of jury trials by 10%, it requires a doubling of all the resources. And if you raise them by 20%, it's a tripling, and so on and so forth. And that is just, and the idea being that is just going to crash the whole system and everything's going to, collapse. And, well, go ahead.
No, I was going to push back on that. So, I'm involved in jury trial reform in Argentina that didn't have any jury trials. And what happened initially is prosecutors kept doing the same thing they kept doing, and they started losing a lot because they would win with the judges because the judges just took everything they wanted. And so what happens is the prosecutors then say, wait a minute, we shouldn't be charging those cases. I don't want to lose. Yeah. I don't want to lose face. Yeah. And so if you give the economic resources to court-appointed lawyers or public defenders, where they can take these things to trial, then I suspect that the reaction on the part of the prosecution can be, wait a minute, we better be a little smarter about what we charge.
Yeah. Well, and I think that happens if you just increase the number of trials anyway. But if the problem for the private attorney is not being able to come up with the resources to, that is a whole other thing. In terms of are the private lawyers that are out there going to be able to fund their own, come up with the resources for experts and all the other stuff that they need. Public defenders, by and large, are going to have access to what they need to get. At least that's been my experience. And if the judges aren't going to give them to them, then they're not going to give them to them. But it doesn't stop you from putting a jury in the box. And putting more juries in the box will increase the load on the prosecutors, and the prosecutors get, then become more careful about what they charge. It's exactly what we saw in Alaska and exactly what we saw in New Orleans. But I think when you're talking about resource-heavy cases, like murder cases, those are a whole heck of a lot less likely to go to trial anyway. I think you can achieve that. I just don't, it's hard for me to imagine a situation where the state puts some kind of, in the environment that we have now, where the state puts some kind of good offer in a murder case on the table and somebody doesn't take it, and then you'd be hard pressed as a practitioner to say, no, don't take that. Don't take that. Let's take our chances with the jury. And it's not what I'm saying in the book. And I don't think that these have to be super expensive or resource heavy cases. I think a 10% swing in, the number of jury trials will do it. And it doesn't matter what kind of trials they are. I see that question come up on the side here too. What should it be? Low-level misdemeanors or low-level felonies or misdemeanors or whatever. I don't think it matters. I think you're just trying to get more jury trials to happen.
And we're nearing 90 minutes. So I'm going to ask Nate or Vanessa if they have questions. They've been monitoring the chat much better than I have, because it's hard for me to monitor the chat while I'm looking at you here. So Nate, Vanessa, do you have questions, or are there questions from the chat you want to pull out?
Martín, I will say two things. One, I hope you're getting some of the ones I'm sending you, but the other thing is we do not have a hard stop at 3:30 unless you do. So the great thing about Engage and Exchange is we have the flexibility to go on if there are other questions. And in terms of, there are a few later ones to address, and I don't know if we fully answered the individual's question. If not, they can pipe in about an interim solution of a trial tax as an express tax to be applied across the board by the prosecution. That is, if you go to trial and lose, we're going to ask for 20% more incarceration, and comments, further comments on that.
So that's one question, Dan. Right? What about what as an interim solution? Can prosecutors just say, we'll ask for 20% more after trial?
It seems perverse to me. If you're going to acknowledge that somebody has a right to a jury trial or not, like either that means something or it doesn't. And for somebody to be punished with 20% more of a sentence because they exercise that right seems to me to be wrong. I don't know. I'm interested in your all's thoughts on that.
I think that I don't know if the person who asked the question wants to say something.
Yeah, if I could, at this point, it's always played as though you're getting responsibility or points for taking responsibility. So maybe I worded that wrong. We will award you a 20% reduction if you take responsibility and don't go to trial. But if you go to trial, this is what we actually think the worth of the case is. And at least this way, the clients aren't left in this black box, this opaque box of, I'm going to get a tax if I go to trial and lose. I don't know what that is, but I'm scared about what this could be. And if it were a modest 20%, whatever, or a standardized amount, at least then everybody's on the same page about what that means. It doesn't go to your kind of systemic solution, but at least it's keeping, if you found a progressive prosecution office that may do this, may keep everybody honest.
I think it's better, at least it's more above board and it's better than what we're doing now. I just think it would also have to come with some restrictions on what prosecutors can do in terms of charge bargaining, you know?
I like the notion of eliminating the uncertainty, Dan. And because I've seen that in my clients' eyes. My clients have expressed that to me, that the uncertainty is one reason they don't go to trial. So I very much see your point on that. But I have two problems with it. One is I wouldn't want to acknowledge as a legal matter, as a constitutional matter, that punishing somebody for the exercise of a right is consistent with that being a right. And that's what Dan was just saying. But also, I think that the question is the percentage, right? If the trial tax that you're talking about, the above board, transparent, everybody knows about it, trial tax is 1%, that's one thing. If it's 20%, that starts to feel heavy to me. And so I think and I'm talking about just at a very practical and real level, that's a real difference. In the federal system, it's 1 to 3 points in terms of acceptance, which doesn't generally have that a 20% impact on the sentence. But I see your point, Dan, about eliminating uncertainty, because uncertainty is a huge part of what drives at least my clients to plead, the fear that they just don't know what the hell is going to happen after trial. Great question, Dan. Thank you. And let me just say, as part of the NACDL effort, one of the things that we were very concerned about, and we talked about, is if we ask for some sort of proportionality between a pretrial offer and a post-trial sentence, is that just going to encourage prosecutors to make much more harsh pretrial offers? We were worried about that. We don't know what the answer is.
Yeah. No, as long as they've got, the capability of charging you with whatever they want.
Well, to me, Dan, this has been extremely illuminating. To me, this is the issue. If we are able to turn this around, able to turn around the trial penalty. And by the way, I hate the name trial penalty. I wish that we had. It's what it really is coercive plea bargaining with judicial complicity.
Yeah.
And if we are able to turn that around, and we call it the trial penalty now because that's what everybody calls it now, and so it's too late to change that name. But if we're able to restore the constitutional balance and take away the coercive element from plea bargaining, we're all going to be able to do our jobs better. I see this as an issue that can really bring together NACDL and its affiliates and the private bar and the public bar and everybody together, because if we change this together, we're going to have a much more fair system. We're all going to be able to do our jobs. And let me just say, as somebody who's been in the trenches a long time, it is psychically and morally, it's just devastating to always be behind this, underneath the thumb of this kind of pressure. It really is, it's devastating.
Well, and for so many of my students that go out and become public defenders, they just don't know any other way. Like they assume, and basically we teach them that this is a perfectly normal way to carry on criminal justice.
Yeah. Well, I think today is another step along the way of NACDL working with people like you to take on this issue. It's the issue that it animates my presidency. It's the issue that I'm completely focused on. I know that other people coming up the ladder in NACDL also feel this way. So NACDL is committed to dealing with this. Nate Peisno has done amazing work. We've got a whole team of people who are doing terrific work on this thing. So on behalf of NACDL, on behalf of my clients, thank you, Dan. Thank you all for being here and for listening. And we'll follow up. And Dan, I'm going to pick your brain for some ideas about how to follow up on this thing. But I really want to thank you for today and for publishing your book and being so generous with your time.
Well, and thank you all so much for having me. And I was looking forward to this because I knew I was going to get a bunch of hard questions and good ideas that I haven't thought of about this. And so I'm going to take some of the stuff that we've talked about back and chew on it some more. And, we'll do this again.
And if any of you haven't had questions answered, please feel free to send them to us and we'll turn them around. So thank you so much, Dan. Thank you, everybody. And stay tuned for the next chapter.
Thanks all.
Vanessa?
I just want to say thank you to both of you. Thank you for an excellent presentation.